today we will do Kailash Chandra dictation transcription number 528. You can get the PDF from description box. So ready? Start. Mr. Vice Chairman, sir, I would like to make a mention of some of the problem of the worker in general and those of the scheduled caste and scheduled tribe in particular. Sir, in the first place, I would like to state that the railway administration does not provide to the worker a speedy and efficacious remedy against their grievances. If a worker is demoted, he has to go to the High Court after appealing to the executive authority. If a worker is superseded, he has to go to the executive authority in appeal and then to the High Court. If he is removed or suspended from the service, he has first to go to the executive authority and ultimately a right is administered to him to go to the High Court. The result is that if a worker is dismissed from service, even though his dismissal is not proper or wrongful, he will not get the relief unless he goes through this channel of appealing to the zonal authority, then to go to Labour Board and ultimately referring the matter to the High Court and lastly the Supreme Court. The result is that in a case where the judicial authority hold the termination illegal and improper, the railway authority are required to pay back the entire wages. It is all right that we have removed and dismissed a large number of workers. I think they are in thousands. What is the outcome of this? The outcome would be that there will be a large number of cases in the High Court and Supreme Court. Ultimately, it would be seen that even if 1/4 of the worker get the relief of reinstatement and back wage, the railway administration will be required to pay to the tune of crore of rupees by way of back wage, and therefore the time has come when we have to consider afresh as to how our industrial relation should be. Sir, my friend has very rightly pointed out that under the industrial law, a worker can certainly, after dismissal, go to the court immediately and get his case adjudicated. That forum is available and that remedy is available. But that is not so in the railways, and I cannot understand what difficulty there could be if you provided a forum for speedy and efficacious remedy. Then the worker will also understand that his case is being judiciously scrutinized and he will feel that he has case and he will not proceed ahead. But when he spent 1 year or 2 years before the adjudicating authority, he knows, and the Honorable Minister would also agree with me that by and large the tendency is to uphold the order of the lower authority, howsoever wrong, illegal, improper, and malified that order may be. That is the tendency, and ultimately, when a judicial scrutiny is held, that order is set aside and the result is colossal loss which the railway are called upon to bear on account of their wrong policy. Therefore, my suggestion would be that it is high time to consider that the railway administration gave every worker a forum where he can seek to the redress of his grievance without much time being consumed in between, and in that way it will be beneficial both to the worker and to the railway administration, and therefore this should be done. This is one of my suggestions. Secondly, sir, even though the railway administration has now taken a decision that all those who had participated in the strike but were not responsible for any sort of violent activity or sabotage or intimidation should be taken back in employment. I can say without being contradicted now that there are today hundreds of workers who have been removed from the work and there is no charge against him, and that they have not done anything that would amount to intimidation or anything that would amount to doing something violent or involving violent action, but still they have not been taken in employment. I have myself represented some of the case. I cannot understand why they have not been taken in employment, and therefore in all such cases there has been inordinate delay in taking them back. The railway board should now examine and find out who is responsible for the delay in the disposal of these cases. This is the responsibility of the railway board and of the general manager or the zonal manager or the divisional manager, whosoever were entrusted with the work of supervising the case and taking appropriate action, and if they have committed impasse, they should be dealt with so that such a delay on part of the railway administration would not be repeated. Then I may point out that in respect of the scheduled caste there has been discrimination. If an inquiry is held, it would be seen that scheduled caste employees have been discriminated against. They were removed from the service though they do not participate in the strike or any violent activity. Thank you. Please subscribe my channel.